We are still passing our condolences from Court Helicopter and myself to the parents who lost their children at Utumishi Academy in Gilgil. 16 children died. The two cabinet secretaries, one for education, Wakili Ogamba, and the other, that is Wakili Murkomen, for internal security, have given the figures and have given the causes. They have confirmed that they have arrested over 8 students, and they are talking of the offense of assault. On this limb, we are focused on the teachers. They have said there was negligence. The Minister for Interior, Murkomen, you can hear him.
Tunajua ya kwamba hiyo institution kuna mambo ya standard procedures ambayo ilifaa kufuatwa. Number one, tunajua ya kwamba kuna one side of the dormitory ilikuwa imefungwa, ya ambayo ingekuwa ni exit ya hiyo dormitory, na hapo ndio wanafunzi 10, about 10 students died at that particular corner. Kwa sababu hiyo kona ilifunikwa, kawekwa kufuli, ikapikwa mbao, alafu ati ni ku-expand the dormitory ndio itoshe ilete wanafunzi wengi kujaza hiyo dormitory. Na kwa sababu ya hiyo, Ministry of Education will take administrative action on the leadership of the school kuona kwamba hiyo haitarudiwa.
Yes, he says the dormitory part of the wing was closed. He admits there was negligence, and he has instructed the DCI to take action. Most likely, teachers, that is the principal of the school, the teachers who are on duty, and the board of management are likely to be arrested and be arraigned in court. What offenses are the teachers and the board of management likely to face? They are likely to be charged with the offense of arson. They are likely to be charged with the offense of gross negligence. They are likely to be charged with the felony of failure to prevent a crime being committed. They are likely to be charged with the offense of abuse of their office for failure to do what is expected. We went into the archives and looked at a similar situation that happened in Kyanguli boys. Kyanguli boys, the students went on riot. And when they went on riot, over 62 students died in a fire in Feno. And the government decided to arrest and charge David Mutiso Kilu and Stephen Musyoka Makau. They were charged. And this is what happened. The appellants, David Mutiso Kilu and Stephen Musyoka Makau, were jointly charged with the offense of failing to prevent a felony, contrary to section 392 of the Penal Code. The particulars of the offense were that between 24th and 25th of March 2001, at Kyanguli Mixed Secondary School in Machakos District, being the headmaster and deputy headmaster, respectively, jointly knowing that there was a threat to set a fire to the school, failed to use reasonable means to prevent the commission or completion thereof of the felony, namely arson, and as a result, boys in the upper dormitory was set up on fire, whereby 67 students were burned to death and 19 injured. The appellants pleaded not guilty to the charge, and after full trial were convicted as charged and sentenced to 8 months imprisonment. The appellants were aggrieved by the said conviction and sentence and have appealed to this court. So they were charged for failure to prevent commission of a felony, and when the trial proceeded, they were convicted, and that is the principle. That time they were called headmasters, and deputy headmasters. Today they are principals and deputy principals. They were convicted and jailed for 8 months each. No option of a fine. Aggrieved with that decision, they went before the High Court. And this is the case in the High Court. That is Criminal Appeal number 155A and 153 of 2002 before Justice Luka Kimaru. Justice Luka Kimaru judged then. Today, Justice Luka Kimaru is a Court of Appeal judge, a very experienced judge. So the argument that was in court was that these people, the teachers, failed to prevent a felony. Let us hear the judge what he says. He says, witnesses gave evidence of various instances before where the students had resorted to illegal activities to gain the attention of the school administration. For instance, in the year prior to the arson incident, the students had broken into the school's students' canteen and stolen therefrom. There were 2 other incidences where the students attempted to set on fire the headmaster's office and also the bookstore. In both instances, tragedy was averted by the quick action of the watchman who saw the fire and put it off in time. Prior to the arson incident, on 25th of March 2001, there appears to have been tension in the school caused by 2 events, which, though unrelated, ultimately contributed more or less to the arson by disgruntled students. 1. The 2 events were the cancellation of the Kenya National Examination results for the candidates who sat their examination in the year 2000. Their exam was cancelled. 2. The second incident was the decision of the school administration to send away students regularly, presumably to get school fees from their parents. Some of the students felt frustrated that the school administration was not sympathetic with the plight of the students. This is the story at Utumishi Academy. This is the story at Moi Girls, Nairobi. Now this is the story we have at Kyanguli. Students not, their issues not being taken care of. The 2 ministers have said the principals were dealing with these students from a military point of view. They were not sensitive that these are adolescents, these are young children. They need to be listened to. They want attention. The school management had no time for this. It goes on. They wanted the school administration, that they wanted the principal to be transferred from the school. They put their feelings in leaflets, which they circulated in the school. The appellant became, the school management became aware of the contents of the leaflets, but unfortunately, it appears that they did not treat the issue with the seriousness it deserved. On the night of 24th of March 2001, the school captain smelled petrol outside the upper dormitory. He immediately informed the watchman, who in their turn informed the principal. The principal, upon being informed of the smell, immediately took action. He went to the upper dormitory accompanied by the watchman. He felt the smell of petrol outside the upper dormitory. He, with the assistance of the watchman, searched the area all over the edges at the dormitory, but they found nothing. In spite of this fact, from the evidence on record, it appears that the principal were alert. They were in school up to midnight. And on that particular day, the witnesses testified that it was very unusual for the principal and deputy and teachers to be in school up to very late, as they did not on that particular day. A roll call of the students was ordered to be taken after the students had gone to bed. The results of that roll call, however, was not mentioned before this court. The principal, before going to his house, assigned duties to the watchman and ordered one of the watchmen to guard the upper dormitory. The principal were woken at 1:30 a.m. with the report that the upper dormitory was on fire. They took immediate action, first to try and put out the fire. So the principal, the court was told how the principal tried with all their machinery, but the fire was there. In my evaluation of the evidence which was adduced in this case, I'm of the humble view that the appellants did what humanly possible to try and deal with the appellant security risk posed by the smell of petrol at the upper dormitory. PW5, a police officer, and this is an indictment of the police, they will always arrest. They have arrested already 8 students. They will arrest the teachers. Remember, when Obwaka died, Dr. Obwaka, they arrested the woman they were with. Even before the postmortem has been done, they have arrested. What was the outcome of the postmortem? Obwaka died of a cardiac arrest. PW5, an inspector of police, Mwabili, the DCI investigating officer, in this case, just like the officers who are in Utumishi Academy, made a decision to charge the principal and the deputy after coming to the conclusion that the appellants, the principal and deputy, had not searched the said dormitory as thoroughly as was expected of them. He further testified that they ought to have reported the smell of the petrol to the police. With due respect to the said police witness, the judge says his decision was informed by his experience as a police officer. His expectations were that the principal and deputy ought to have undertaken a forensic search of the dormitory. The principal and deputy could only conduct the search according to the understanding of the situation then prevailing. The principal and deputy alleged failure to report to the police, in my humble view, was not an issue in this instance. The principal and deputy were of the considered view that they had the situation in control. A reasonable headmaster and deputy in the circumstances would have taken the same action, and that the appellants did. It is my humble view that the prosecution in this case seems to have been informed by the fact that the education administrators at the time felt that somebody in the school administration ought to be punished for the tragedy. The judge is saying it is not the principal and the deputy to be charged. It is the ministry officials. But the ministry officials decided to sacrifice the small fish. We are going to see the same. Teachers are going to be arrested. Teachers are going to be taken to court. The judge is saying the principal happened to be convenient targets. That is Justice Kimaru. The principal and deputy were convenient targets. To find the principal and deputy guilty of failing to prevent a felony in the circumstances of this case could be taken akin to finding the mayor of Nairobi. That time there was no governor. So today, if it is here, we could be saying finding the governor, Sakaja of Nairobi, guilty of failing to prevent a felony when City Hall, that is the county government of Nairobi, that time City Hall, recently was destroyed by fire, putting into consideration the fact that the Nairobi City Council had resources to prevent the fire, and subsequently, when the City Hall was set on fire, the resources to prevent the destruction of the said City Hall. The judge is saying you cannot charge the teachers. You cannot charge the principal and the management board. You need to charge those who fund the school. He compares it with Sakaja. When fire burns at City Hall, do you arrest Sakaja? That is the question. The judge is saying, from the foregoing, I find that the prosecution case has not proved, as a consequence of which the appeals filed by the principal and deputy have to succeed. The appeals filed by the principal and deputy are therefore allowed, their convictions quashed, and their sentences set aside. The principal and deputy are set at liberty unless otherwise lawfully held. Dated and delivered at Nairobi on this day, 30th day of April 2004. Justice Luka Kimaru. What are the lessons in this, considering the Utumishi Academy issue? The dome is not built by the teachers. The facilities called fire extinguishing facilities are not provided by the teachers. So anybody who should take blame should be the top dogs at the Ministry of Education, the top dogs at the Ministry of Interior, the security apparatus of that region. Utumishi Academy is built within the land owned by the Kenya National Police Service. The school has more than 80% children of serving and retired police officers. The security situation of that area is a top-notch security zone. It borders several military installations, several police training installations, several NYS installations, several GSU installations. It is at the center of Gilgil. Gilgil is a serious security town. What went wrong? So, from this episode, if they are still following to arrest the teachers and charge them, the teachers will be acquitted, because, as in Kyanguli case, the teachers are human beings. None of the teachers is a trained policeman. Teachers, like myself, I did a degree in bachelor's degree in education. They have no forensic education being conducted at university. They don't undergo investigation training at any university. They don't undergo any type of drills at education institutions. These are ordinary citizens. In their brains, they know the knowledge to teach, to impact knowledge. Teachers are not watchmen. Teachers cannot be blamed for an occasion as what we call a systemic error. I stand with the teachers of that school, and I stand with the teachers, the whole country. Let us not demonize the teachers. Let us not deal with this issue. The teachers are likely to be taken through the administrative disciplinary procedures of the Teachers Service Commission. They will defend themselves. If they are found culpable, they can only be dealt with professionally if their negligence is professional. No teacher, we have checked from the record, no teacher has been charged over a fire arson in a school and has been convicted. But they can be dealt with administratively by the Teachers Service Commission. I have seen the CEO, acting CEO, Madam Mitei, say the TSC will conduct their disciplinary procedures as provided by the Teachers Service Commission. But as a former teacher, I stand in solidarity with all the teachers. Let them not be blamed when the systems have failed. The facilities provided by the school are not provided by the teachers. Teachers are not policemen. Wakili Dan Stanomari.